Manever I say ma PENDREAM TV. PENDREAM TV there, osia dem yopo.
You are most welcome to PENDREAM TV, the only channel that brings you the best and latest updates in politics. If you are new here, please don't forget to subscribe to the channel, hit the notification bell for more updates, like and also share to other members to watch as well. You can equally leave a comment after watching or send us a voice note on our WhatsApp number, 0277 128 777. Thank you. Join me listening to what we have for you today.
Election process advanced to collation of results at the constituency level in order for the winner of the parliamentary election to be determined and declared. In the case of 4 of these constituencies, the applicants contend that the collation exercise had completed and then the parliamentary electoral results were declared in their favor. In the processes before us, the 1st to 7th interested parties contend that the collation of results was not completed in those constituencies. It was in this state of affairs that the 2nd to 7th interested parties filed series of applications in the High Court and prayed for orders of mandamus against the Electoral Commission, which is the first interested party herein. Their prayers were for the High Court to order the Electoral Commission to undertake collation in their constituencies and to make a declaration of the winner of the constituency election. In the meantime, the applicants herein had earlier on 16 December 2024 filed an application for judicial review against the Electoral Commission, in their case praying for declarations that there had been earlier declarations in their respective constituencies and praying for injunction to restrain the Electoral Commission from doing another collation. On 20th December 2024, the 2 applications were listed before the trial High Court judge for hearing. The first application called by the trial judge was that for mandamus by the interested parties herein. The Electoral Commission did not file an affidavit in opposition and stated in court that they were not opposed to the application for mandamus. However, Mr. Godwin Edwigi Tema of counsel for the applicants hearing stood up in court and informed the High Court judge that his clients were interested in the mandamus application and that they had even filed a motion to be allowed to join the mandamus case. The judge decided to proceed with the determination of the mandamus application and granted all of them in favor of the applicants therein. It is those rulings dated 20th December 2024 that the applicants have invited this court to quash and to prohibit the trial judge from having anything to do with the applications. The grounds of the applications were as follows. I've listed them in accordance with the motion paper. The interested parties filed affidavits in opposition with exhibits as well as statements of case in which they argued in answer to the case of the applicants. Before the courts could hear the application, counsel for the 2nd to 7th interested party raised a preliminary objection and pointed out that the rules required that at the filing of the application for certiorari, the ruling which is sought to be quashed should be attached, but that was not done. The court indicated that the application should proceed and that in the final ruling would answer the charge. Our conclusion was informed by the fact that there was an explanation in the affidavit as to why the ruling was not attached. And we took note of the fact that now the rulings are before the court, and in order to determine the merits of the applications, which have been well argued by both sides, it was in the interest of justice to proceed. So we proceeded. Counsel for the plaintiff, for the applicants, first stated that since at the hearing on 20th December 2024, the trial judge was notified that the suit were affected by the proceedings for mandamus, the judge ought to have joined them to the case in order that they could file affidavit in opposition to the grant of the mandamus. He further submitted that since their application filed on 16 December 2024 was listed before the judge for hearing the same day, the judge had knowledge of their contentions that collation had already been completed and declarations made in 4 of the constituencies. So he ought to have permitted them to put that evidence before him in respect of the mandamus application. Additionally, the applicant stated that the procedure rules on judicial review in the High Court, which were applicable in the case of the application for mandamus, being Order 55 of the High Court Civil Procedure Rule CR 47, made ample provisions for interested parties to be added to an application for judicial review, but the trial judge failed to apply these provisions and to add them. Counsel for the applicants relied on a number of decided cases, especially Public versus High Court Bolgatanga, ex parte Hawa Yakubu, 2001-2002, Supreme Court of Ghana law reports. Counsel for the applicants further stated that the trial judge exhibited bias against the applicants by not only failing to admit them into the mandamus application, but by opting to hear the mandamus application first when their application for declarations and injunctions was filed earlier in time. In answer, lawyer for the first interested party relied on the statement of case he filed and added that he observed that none of the individual parliamentary contestants had an affidavit before the court in which they complained about any miscarriage of justice. Lawyer for the second interested party, the second to seventh interested parties, stated that he was vehemently opposed to the application. He pointed out that the applicants built their case on the failure of the trial judge to join them to the mandamus application. But he submitted that the rules of the court on non-joinder of a party is to the effect that non-joinder does not vitiate proceedings. He referred the court to the case of Bobier versus 21st Century Company Limited. He submits that the judge had a discretion given to him in the application for judicial review to join interested parties if it was in his opinion. If it was in his opinion that they would be affected by the proceedings. The trial judge did not consider the applicants necessary parties and he exercised his discretion against joining them. He submits that such order would not be granted to quash the exercise of discretion by a trial judge. He referred to the case of Republic versus High Court, the Republic versus Court of Appeal, ex parte Chachichikata, 2005-2006 Supreme Court of Ghana law reports. Now, the consideration. In our opinion, the crux of this application is whether, under the circumstances that the trial judge was faced with, could he have proceeded to determine the mandamus applications without hearing the applicants in the form of affidavit evidence and legal submissions on whether the case before him, notwithstanding non-opposition by the Electoral Commission, was a proper case for the grant of an order of mandamus. It is very clear to us that it was plain to the trial judge that the clients of Mr. Godwin Edwige Temaklo stood to be affected by the proceedings in the mandamus application. And the least he could have done was to grant them a hearing on the facts and the law upon which the application was brought. Our courts and all courts, especially in the common law tradition, have held this right to a hearing so sacrosanct that under the circumstances of this case, the applicant ought to have been given a hearing, notwithstanding or irrespective of the provisions of Order 4, Rule 5 of CI 47 on joinder generally, and Order 55 Judicial Review. In the case of Awuni versus West Africa Exams Council 2003-2004, Supreme Court of Ghana Law Report, the Supreme Court quashed a decision of an administrative body, that is the West Africa Examination Council, for failure to accord persons a right to a hearing. The statute under which the West Africa Examination Council functioned did not expressly confer a right to a hearing, but the Supreme Court held that the West Africa Examination Council ought to have accorded those affected a right, since the right to a hearing had been elevated to a constitutional right in Article 23. If that had been held to bind administrative bodies, how much more a court of law? In the case of ex parte Hawa Yakubu, the High Court in Bolgatanga made orders in an election matter which affected Hawa Yakubu, a candidate at the election. And though she was a non-party, the Supreme Court held that on the facts in the case, the High Court violated her right to be heard and quashed the orders of the High Court. The interested parties say that because Mr. Godwin Edwige Temaklo was allowed by the trial judge to speak, he was accorded a hearing. But they must realize that he was allowed to speak as a friend of the court, as recorded by the judge himself, and not as counsel for the applicants. This is an unfortunate misunderstanding of what amounts to a hearing in the mandamus application of this nature. Hearing plainly required the applicants to have filed an affidavit in the matter and to have made legal submissions. In this case, none of that happened, so the trial judge violated the right to a hearing of the applicants. Now to our orders. We have taken notes of the fact that the applicants did not contend that there had been earlier completed collations in respect of Nsawam Adwajiri and Ahafo North constituencies per paragraph 8 of the affidavit sworn to by Fifi Fiavikwete dated 16 December in support of the motion for judicial review filed by the applicants on 16 December 2024. Since the orders which have been brought to be quashed are separate and distinct, we have decided to exercise our discretionary power to quash by certiorari, having regard to the peculiar circumstances of each ruling. Consequently, we hereby quash the orders of mandamus made for collation of results by the Electoral Commission in the following constituencies. 1. Okaikwei Central. 2. Ablekuma North. 3. Tema Central. And 4. Techiman South. Accordingly, the collation of results in the above constituencies by the Electoral Commission after 20th December 2024 on the orders of the court are hereby set aside. For the avoidance of doubt, the orders of the High Court made in respect of Nsawam Aduajiri and Ahafo North are not affected by this order, by this our order, and in effect, those declarations stand. Despite quashing the orders stated above, the applications for mandamus themselves are still alive and ought to be heard and determined. In line with our conclusion on this application, we exercise our powers under Article 1294 of the 1992 Constitution and make an order pursuant to Order 55, Rule 65, to the effect that the applicants herein are granted leave to file affidavits and statements of case in answer to the respective applications for mandamus which have not been quashed. No, which have not been quashed. Those which have not been quashed. They are still extant. Those which are quashed, yeah. Now those which have been quashed. Those which have been quashed. Yes. To file those which have been quashed as interested parties. The time for filing is hereby abridged to 2 days from today. The applicants for mandamus in the High Court upon service may respond to the processes of the interested parties. Having regard to the circumstance of time constraint on the national electoral calendar, we hereby abridge the time for the hearing of the mandamus applications in the High Court and direct the High Court to hear the applications for mandamus on Tuesday, 31st December 2024. I hope Tuesday is 31st. On the issue of bias, we are not satisfied that sufficient evidence has been provided to us by the applicants. Nevertheless, in order to maintain the integrity of the adjudicatory process and in line with the practice of this court in cases such as Republic versus High Court ex parte, Ajua Company Limited, Auditor General Interested Party, 2019-2020 Supreme Court Law Report of Ghana, Adare, we hereby direct that the applications for mandamus that are extant shall be placed before a different High Court judge for hearing and determination. To conclude, by the conclusions reached in this decision, reliefs A1, A2, A4, and A5 endorsed on the applicant's motion paper are hereby granted, while reliefs A3 and A6 are refused. Reliefs B and C are hereby dismissed. Ordered accordingly.
My lords, we are extremely grateful, extremely grateful.
We are grateful to the court. My lords, we are grateful. My Lord, there's a second motion on your docket.
Respectfully, my lords, civil motion number JA/30/2025. The Republic versus High Court General Jurisdiction 13, Accra. Ex-party, the National Democratic Congress. National Democratic Congress. Baba Sadiq. Erabna Oben. Amenope Philibert Fomi. E.B. Bright. Christopher Bayer. Akwesi Edusei. The Electoral Commission of Ghana. Patrick Yalboama. Nana Ekia Owusu Efriye. Frank Ano Domper. Charles Forson. Martin Kweku Ejay Mensah. Eric Nana Ajiman, Inspector General of Police. Respectfully, my lords. That is so.
My Lord, that is so. The same time. And the same representation.
Council, the same representation, Council.
That is all, my lords.
Okay.
Let's replace that person with Nana Befi Yeboah. He will replace Nana Ejay Bafo Ewa. Nana Ejay Bafo Ewa.
Nana
Ejay AJYE. Bafo.
Okay, no.
Bafo Ewa.
Yes.
Ewa.
The lawyer,
Yeah, he's a lawyer.
yes, and then now MP.
Yes.
MP elect.
MP elect, yeah. Well, for the 2nd to 7th interested parties.
So, Bafo Ewa has been replaced by Nana
Befi Yeboah. My lord's Befi, BAAFI, and then Yeboah.
Okay. Thank you. So, what is the fate of this application?
My Lord, in view of the fact that the orders we're seeking to stay have been passed, we will seek leave of this court to have the application withdrawn.
Yes, Mr. Menugo. Any opposition?
No, my lord.
Mr. Nimako?
I lost no objection.
There be no opposition or no objection to the prayer of the counsel for the applicants. The application for stay of execution is struck out as withdrawn.
Extremely grateful.
To give me some little cost.
No government.
I think when you finish the whole thing, when you finish the whole matter,
The whole matter.
yes. Yeah. Yes, Inspector General of Police is presenting. I believe you are here. Okay. So you are being moved into all of this. We notice that you didn't file any processes. And it's understandable because your role is very crucial. The role of the police is very crucial. You see what this application has done. During the application that we should do, we should let me go to the lesson. We all have to come. We decided that instead of adjourning for a judgment or to give you a ruling without reasons, in order to forestall any unnecessary comments and therefore disruptions, that is why we constrained ourselves and did this. So also play your role as a convey to IGP, you play your role. Neutral persons, and then make sure that we avoid situations which can lead to an escalation of any disruptions. Okay? Okay. They are not here. There is the lawyers who are. At least there's a general secretary here, Mr. Fifi Kwete. Yes. Yes. We also think, as we are talking to the police, make their work easier. You, the political parties, make their work easier. Try and then also help so that we have a peaceful atmosphere as we go forward. Thank you.
All rise.
Right, these are changing the results. Yes, nobody has been looking. This is a full card. Is it? Shut up.
Thank you for staying tuned.
Dedi kama mamena PENDREAM TV ase. Na so far so good. Say open online portal e wo Ghana. Ah nipa share, nipa follow, nipa comment here. To my best of knowledge, without any biases, PENDREAM TV.